here former Vice President Joa Howard Taylor, representing the NPP, Councillor Koo representing the ANC, and several other political parties. We move to the chairman of the committee, Councillor Chair.
Okay, so the most senior person. Seniority. Yeah. So, the party, as the chairman of the team, the media representative, the president of the union, CDC, and the most senior. Speak for the CDC. It's time. We'll give each of you. We will be with time. But I think, sorry. I think 10 minutes should be sufficient, right? Or 5 minutes, what do you think? That be less? 5 minutes sharp? So let's say 10 minutes. Will 10 minutes do? Yeah. 10 minutes. You don't have to. If you got something to read, maybe you can get after it. Whatever you have in there, then during the discussion, you can put the wire for it. If that is okay, yes. Then we all agree that each of you will have 10 minutes to speak. May I also add whether you were all said happy of the proposed election amendment? Yes. Yeah. Because you have to be informed. If you are not, if you don't have, then we expect you to speak to somebody you don't know about. You don't have. So if you have, do you all have that? But that document, that issue been communicated and sent to all of you. Yes. If you have an opportunity to read it.
Mark, we would like to speak on that.
Okay, so we'll come to okay. All right, so let me not jump the gun. So we'll come to that. We'll come to that. So I want to give the first opportunity to the former Vice President with the Senator. Am I correct? Senator of the NPP to speak. To make a presentation.
Thank you, Mr. Chairman. The Honorable Chair and members of the Senate Committee on Judiciary, Human Rights, Claims and Petition, fellow members of political parties, we want to say thank you for inviting political parties and some other important organizations to this hearing. I want to note first that there are some very important parts of this process of which some of the people invited are not here. I think it's important to take a note of that. The Election Commission, the Nigeria National Bar, Governance Commission, those are important parts of this process, and I hope this may not be the last hearing so that we get a chance to hear from everybody else. But for while we are here, I want to just say initially that democracy is not sustained by elections alone. It is sustained by the strength of the laws that protect the people's voices, and the integrity of the institutions that administer them. From the side of the National Patriotic Party, we received the documents. We didn't have much time, so we might not have the time to delve into every issue, but I will try my best to be as short as I can so that I utilize the 10 minutes that I've been given. We want to propose a new chapter, and we think this is important. Anti-defection provision that talks about an elected official who resigns from the political party on which he or she was elected and joins another party should automatically vacate that seat. And there are provisions under which it will lie. But you know, when someone gets elected, the mandate belongs not only to the candidate, but to the political party and the platform on which you were elected. I believe all of the jumping we see back and forth, you get elected on a party ticket, that party gives you all of the support, and you come into the legislature in 3 months, you decide you no longer want to be there, you jump somewhere else. I think this will strengthen party discipline, protect the will of the voters, and reduce political opportunism. Our second point is strengthening political party registration and an amendment to section 1.2C. We believe that the 500 members in 6 counties is too low. You look at our population and you look at what it now requires to win an election. We would like to recommend that the number of persons that the political party should have across the country is a minimum of 1,000 in at least 10 counties. If you just say 500, everybody will have a political party that really doesn't even have a base. Political parties should maintain functional offices in the 10 counties. They should have gone through a democratic process to elect their leadership, and they should have minimum requirement of men and women. We believe that this amendment will promote national political parties, will reduce the briefcase parties, and it will also strengthen political institutions. Our third point is the retention of the 2% rule. We support this retention rule because it requires that a registered political party must either obtain at least 2% of the total valid votes cast in a presidential election, or at least win 1 seat in the legislature. If you don't fit this bill, then you're not a real political party. And I think laws should be put in place to ensure that those people who don't fit the bill are actually removed from the political role. It will also strengthen our democracy. Our fourth point, domicile versus residence. Something strange came up as we look at this particular portion of the law. And it's now calling for a voter shall register and vote. While democracy requires political pluralism, it also requires political seriousness. The purpose of this 2% rule is not to silence political voices, but to ensure that registered parties remain connected to the ground. That was just the end of that. The next point is domicile versus residence. Proposed amendment to section 1.2. For voter registration purposes, we believe that residents should take precedence over domiciliary. And our recommendation is that a voter shall register and vote in the constituency where he or she has maintained a principal residence for not less than 12 consecutive months, immediately preceding registration. This amendment will ensure that people actually vote where they live. We now have an issue of trucking voters all over the country, offsetting elections in many places. In some instances where the population number is very small, all you gotta do is move 500 people. You can offset in elections in any area. People don't live there, because they affect the results of the election in those areas. Maybe somebody wants Peter Ford and you end up getting John Brown because John Brown truck people. I think this clause is very important that people vote where they are staying. It will increase the support to the provision of the law that says people should not be trucked. It's already an illegal portion on our laws, but no one is paying attention to it. Our fifth point is diaspora voting, and we oppose the insertion of this phase, including citizens resident in the diaspora, in our laws. During President Weah's tenure, there was an issue about citizens not losing their citizenship because of the war, and they had traveled to different places. Supreme Court has already taken a decision on this matter, that once you are a natural born citizen, you don't lose your citizenship. So those who want to take part in the elections from the diaspora can come and register and vote. You're a bona fide Liberian citizen. To start to introduce the issue of diaspora is a problem. It's against what the Constitution requires, because they say you must live and work in Liberia. So I think we need to look at this in a very, very, very strong way. Our position is that Liberian citizens residing abroad already retain the right to return home to register and to vote. So there's no need to add this diaspora thing that will really just bring more confusion. 6-point publication of the voter roll. They've left the clause empty that they can publish a voter roll as long as it is done before the elections. The NPP says no. We are asking that a time frame be added, because the Election Commission could post the roll 2 days before time, and we might not have had a chance to really look at it. We're suggesting that not later than 90 days before the electoral process. that will allow proper verification, correcting of errors, and reduce election disputes. Prior to the election date is too vague and open to interpretation. Our 7 point is that we support the 30% general representation requirement. For me, I've been talking about this for many years, so I'm happy that it is now going for an endeavor to ensure to show. The 30% requirement is not a favor to women or men. It is an investment in a stronger, more representative, and more inclusive democracy. Number 8, polling hours. The new laws are suggesting that the voting period goes from, we had 8 to 6, and they're deciding to take it from 8 to 4. I don't think there's any justification for this. Each polling center has about 500 ballots to count. What would the 2 hours do? But I think we should retain it as it is from 8 to 6 so that we won't bring more confusion. Some people might be able to go to the polling center at 5 o'clock because maybe they have to work. So we shouldn't disenfranchise our people by reducing the number of hours from 8 to 6 and reducing it from 8 to 4. So the MPP is against reducing its time. Last but not the least, application and registration fees for expirants. They are currently proposing $5,000 for the president, $3,000 for the vice president, senator, $1,500, and representative, $1,000. I think anyone who wants to be president of their country and to vote and pay $5,000, I think these fees are too small. And it provides an environment where people who are not even serious and just go look for $5,000 a pay. So we're recommending that we increase it. President at 15 or 20, I was talking 25,000, but the people say are very extreme. So, but the MPP position is that the presidents pay a minimum of 15,000, the vice president 10, senators 5,000, and representatives 3,000. We believe that these amendments will help us strengthen our political institutions, promote electoral integrity, and expand our participation across our country. Thank you, Mr. Chair. These are our initial comments.
Thank you. Do you have copies?
Yeah, copy of it. Yeah, the copies are in ready. In our folder.
Oh, yes. Thank you so much.
Okay, copy of it. No, no, you can come.
Yes, sir.
I just want to provide this information that the bill we are discussing is a bill that we proposed by a member of the House of Representatives. It was passed from the House to us. It is not from the executive. It is not from us. It is a bill that was proposed by a member of the House of Representatives, passed by the House, and sent to us. That's what information.
Right. And in addition to that, we are informed by NEC that the executive is working on their own version that will be submitted to us. We don't want it to be too voluminous. That's what we decided to do them in piecemeal as we had went down. We deal with it one time. We look at them, share copies with you as we have done in this case, and then we get our input. Next, we have the UP.
Thank you, Mr. Chair and honorable senators. Let me first of all thank you for the opportunity to invite the Unity Party to this very important electoral reform discussion with colleagues and with all stakeholders in the country. This discussion is truly consistent. The consistent review of our electoral law is very compatible to good governance, and the Unity Parties surely appreciate this move by the House of Representatives. The document to the Unity Party office and on my desk was received 10:50 a.m. this morning. Even though the letter was signed around June 16, 2026, it was just 10:50 this morning. And because of the importance of this dialogue and engagement with stakeholders, we had to readjust our schedule as much as we can to be part of this discussion. So let me offer my kind apology that a rating statement is not prepared from the UP, not because we are trivializing this engagement, but because we received the letter just 10:50 and we got here by 11:15 this morning. So we have passed this document over to the United Party's lawyers, and we are going to prepare our observation. Even myself as the chairman, having perused the document, I've seen some major things that, in my opinion, that needs to be addressed. But the UP lawyers will look at it and come up with a comprehensive observation from the party. So on this note, Mr. Chairman, let me kindly apologize, not intentional. It's because we got the letter very late. And I can assure you that this week we are going to prepare our rating observation in the document and submit it to the Secretary's office. Thank you very much.
Thank you, Mr. Chairman. Of course, the committee understand that if you see the communication this morning, we're not expecting to respond to it. We receive it prior, we do. So we'll give you that special dispensation. Please, let's hear from you maybe the next 5 minutes.
Yes, sir.
Thank you.
Thank you, Mr. Chairman.
Next, CDC.
Thank you, sir. Mr. Chairman, members of the Senate, I present to you the CDC.
Honorable Israel Akensanya, representing the CDC.
Presented to the Senate, and we're very pleased to be here to expand on that. The Congress for Democratic Change presents its compliments and acknowledge receipt of the commission's, the committee's rather, invitation to parties and stakeholders to participate in a review of the proposed amendment. While the CDC welcomes genuine electoral reforms designed to strengthen democracy, enhance transparency, and increase participation, and promote confidence in the electoral process. However, no electoral reform shall become an instrument for weakening constitutional guarantees, diminish political competition, restrict access to remedies, or creating institutional arrangements capable of compromising the integrity and the independence of elections. After a careful review and comprehensive review of the proposed amendments, the Congress for Democratic Change has identified several provisions that raise constitutional, legal, and democratic concerns. Number one, attempts to concentrate excessive authority in a National Elections Commission. The proposed amendment, viewed collectively, seeks to centralize substantial powers over voter registration, claims and objections, investigation, adjudicating, staffing, and disciplinary actions, and electoral administration in the commission itself. Such concentration of authority undermines the doctrine of accountability and creates the unacceptable possibility that the commission may simultaneously function as an administrator, investigator, prosecutor, witness, and litigant. No institution in a constitutional democracy should be permitted to serve as judge of its own case, of its own cause. The CDC therefore maintains that institutional independence must be accompanied by transparency, accountability, independent audits, judicial review, and effective participation by political stakeholders. 2. Reduction of polling hours constitutes a threat to voter participation. The proposal to reduce voting hours from 8 a.m. to 6 p.m. and take it to 8 a.m. to 4 p.m. represents a retrogressive measure that is inconsistent with democratic expansion. Such reduction disappropriately affects rural communities, women, elderly citizens, persons with disabilities, and the working class voters, citizens who must travel long distance to polling centers. The right to vote, guaranteed under Article 77 of the Constitution, demands maximum access and participation, and not restrictions. Accordingly, the CDC strongly opposes any reduction in polling hours and recommends retention of the existing time framework or such extensions as circumstances may require. 3. Reduction of the complaint period to 48 hours is unconstitutional. Among the most troubling provision contained in the bill is the proposal to reduce the complaint period from 7 days to 48 hours. Article 83C of the Constitution expresses guarantees the right of political parties and candidates to challenge election results and electoral conduct within 7 days following the announcement of the results. This constitutional safeguard cannot be curtailed by ordinary legislation. Any attempt to impose a 48-hour limitation effectively deprives party and candidates of meaningful access to evidence, legal representation, and due process. Rights guaranteed by the Constitution cannot be rendered illusionary through procedural barriers. Accordingly, this provision is unconstitutional. It should be deleted in its entirety. Exclusion of party representatives from polling centers undermines transparency. That's the next one. Number 4. The proposed repeal of section 4.10(1), which presently guarantees the presence of party representatives inside polling places, constitutes one of the most dangerous provisions contained in the proposed legislation. Political party agents are indispensable safeguards against ballot stuffing, intimidation, manipulation of counting, alteration of results, electoral fraud. Removing explicit statutory protection for party representatives threatens transparency and undermines public confidence in the process. No democratic electoral system can be considered credible when political parties are denied effective observation rights. Therefore, this provision must be rejected in its entirety. Expansion of precinct size while reducing voter hours creates conditions for voter suppression. Increasing the number of registered voters per precinct from 3,000 to 4,000 while simultaneously reducing polling hours creates a dangerous combination likely to result in overcrowding, long queues, confusion, delays, disenfranchisement. Such provisions collectively reduce conditions favorable to electoral manipulation. The existing limit of 3,000 voters per precinct should therefore be unchanged. That's 5. Number 6, the RASPA voting must be subject to strict statutory safeguards. The CDC supports the principle of extending voting rights to Liberians residing abroad. However, the RASPA voting cannot be administered solely through broad discretionary power vested in the Commission. Such framework must contain clearly statutory safeguards, including biometric verification, transparent voter rolls, chain of custody procedures, party observers, secure transmission mechanism, public tabulation procedures, judicial review by the court. Without such safeguard, the RASPA voting risks becoming susceptible to abuse and controversy. 7. Proposed restriction on political party headquarters are unconstitutionally repressive. The proposed Chapter 5A requiring political parties to obtain approval before establishing headquarters within Monrovia and its environs represent an unprecedented intrusion into the constitutional liberties. Articles 17 and 18 guarantee freedom of assembly and freedom of association. No constitutional authority empowers the National Election Commission to determine where political parties may establish office. Such powers create opportunities for discrimination, selective enforcement, and indirect political control. Consequently, the entire chapter should be rejected. 8. Excessive increase in candidate registration fees, discrimination against ordinary Liberians. The proposed doubling and tripling of nomination fees constitute barriers to democratic participation. Democracy cannot be reserved for wealthy individuals. Only excessive financial requirements discriminate against young people, women, independent candidates, opposition parties, economically disadvantaged citizens. Article 77 guarantees equal political participation. Therefore, the proposed increase should be withdrawn. 9. Provisions installing election results from the consequences of legality are unconstitutional. The proposed section 5.4 suggests that criminal violations shall not affect the outcome of elections. It's perhaps one of the most constitutionally offensive provisions in the entire bill. No legislative processes, but no legislature possesses the authority to predetermine that lawful acts cannot invalidate an election. Whether irregularities materially affect results is a judicial question reserved for competent courts. A statute cannot legalize fraud or immunize illegality. The provision strikes at the heart of Article 83. Yeah, Article 83, due process, and the rule of law must therefore be removed. Number 10, imposing burdens of proof destroy access to justice. The proposed requirement that complaints prove that violations would necessarily alter the overall outcome of an election creates an unreasonable and nearly impossible burden. In many cases, the commission to alter voter rolls must be accompanied by public display of rolls, party access, independent audits, biometric verification, appeal mechanism, judicial review. The integrity of the voter registry is fundamental to free and fair election. Number 8, gender. The Congress of Democratic Change remains fully committed to increasing women participation in politics. However, automatic disqualification of party lists creates opportunity for selective application and abuse. The CDC supports incentive-based approaches, phased implementation, and fair enhancement mechanism rather than punitive exclusion. Reforms to the appointment, tenure, and operation of the NEC. The National Election Commission, under Article 89, is a constitutional institution and not an appanage of the executive branch or temporary political majority. Accordingly, any amendments affecting the appointment, tenure, quorum, removal, and operation of the commissioners must preserve impartiality, security of tenure, transparency, and public confidence. No ruling party should be permitted to redesign the electoral referee in a manner that compromises its neutrality ahead of the national elections. Conclusion. Viewed individually, many provisions may appear merely administrative. Viewed collectively, however, the proposed amendments reveal a disturbing pattern aimed at concentrating authority, restricting participation, limiting remedies, weakening oversight, reducing transparency, and insulating control electoral outcomes from meaningful judicial scrutiny. For these reasons, the Congress of Democratic Change respectfully calls upon the legislature to suspend further consideration of the proposed amendments in their current form and to convene a broad-based national election reform conference involving all registered political parties, the Liberian Bar Association, civil society, ECOWAS, women organizations, youth organizations, religious institutions, disability advocacy groups, and domestic and international election partners. CDC further reserves all constitutional, judicial, and lawful political remedies available under the Constitution of Liberia to any enactment threatening the integrity, transparency, and credibility of the 2029 electoral process. Thank you. And we will provide a full copy of this to each one of your office within the next 12 hours. We'll provide this copy. Tomorrow. So the secretary sent 7 copies.
All of them submission. Please, let me take care of it. Okay, while you were in speech, we had two of our colleagues entering the room. The senator from McGee, and Boy Child Sobey. Putting Boy Child behind him, and that's a bit ability. Yes, and Emmanuel Dupree, member from the he comes. Oh, okay, sorry. Okay, so Yaya Libre from thank you. And the matter speaking to by the MPP, we just want to let you know that something that we need to change. Amendments that we need to make. Please just put them in a separate section as your recommendation. It's a whole review process. So we'll also with the version from the executive when that comes. There's also the version that the Senate passed. Not the Senate, but the legislature passed a couple of years ago. There were 9 vetoes by the former president. Also, we'll also have that. We'll review all of the instruments and come up with a harmonized version that we share with you to make a final input, including the input that you also made. But that was not comprehensive piece of work. Okay, because it's important that we do that. We said the practice of the election law, there have been a lot of issues. We want to address all of them at this time. Thankfully, we have a little bit of time until the next election. We want to start that. We're starting that now. Hopefully, maybe by this time next year, we might be close to finality. So please put time into it. Look at the entire law, the amendments, proposed amendments. Look at them. Look at all of them, and come up with whatever recommendation that you may have. Then we'll call you back again. Okay, we'll call you back again. Because each of you will be making a recommendation. We'll share the recommendation with each of you. You agree, you don't agree. Then we come back and say, okay, why do we all agree upon one part? That's what we'll do. That will be the next stage, the final stage of that. Then it's the contemplation of that will prepare the final instrument. So please sign it. Yes, sir. What? Yes. Please share copies with witnesses. Okay, ENC.
Thank you, Mr. Chair and members of
Please again, one more time, please again, take your time to look at these instruments. Please take the time. Okay. Hopefully we have exclusive and law reform commission from the Bar Association and others, but they promise to be identical. So we'll be separate. Thank you. Please go ahead.
Thank you, Mr. Chairman and members of your esteemed committee. please permit me to ask that you just make a slight amendment in your housekeeping rule. I just wanted to provide information, and so my colleague who has been seconded on this will then speak to it.
Oh, yeah.
Thank you. Thank you.
It's fine with us. We got no problem.
All right, thank you. Mr. Chairman, because this tax is very important to our country, and we see the different approach you are using to go about these public hearings, we want to just urge you, if we may, that the notices that you will send to us, provide us some time so we can submit to you papers that will be very helpful when you are closed door and deliberating on your home.
We take that on advice.
Because of that, we didn't come with a prepared paper.
We take that on advice.
Because of that, we didn't come with a prepared paper, but we have something. With that, now I'd like to defer to Councillor Mariah Yakula Kokpo, who will now present on behalf of ANC as the Vice Chair for Legal Affairs. Thank you, sir.
Thank you, Chairman. Honorable Senators, our preliminary review of the document sent to us, we would like to present a few points. First, the document sent to us references amendments to the 1986 elections law, which is the 2014 new elections law. Unfortunately, we did observe that some of the provisions in the law were strictly from the 1986 law. And so this appears to be an amendment to both the 1986 elections law and the 2014 new elections law. So we'd like that to be noted and reflected in the proposed amendments or the bill passed by the House. As for the specifics, we do want to agree with the use of residence over domicile, but however, in the definitions, domicile as defined does not reflect any reference to payment of taxes. That is usually an indicator of domiciliary, and we would like that to be referenced in the definition of domicile. We also want to speak to the qualifications of the Executive Director of the NEC as amended or proposed, and there was an inclusion of qualification for a degree in education or computer science, which we don't have the background on. We don't understand what the rationale is. We would like to have some clarity on that, hopefully. Get some background on that to inform our decision on that, but we just could not put a finger on that. The fourth point for us is the verification of citizenship. This proposal restricts the verification of citizenship. These are documentations that are required. And so for our people in the villages and the towns, we think that this proposal seeks to prevent them from being registered to vote. Our fifth point is diaspora registration. We support wholly diaspora registration. We believe that every law has exceptions, and Liberians everywhere remain Liberians and should not be disenfranchised from participating in the elections. We, however, want to go further to propose that not only should we provide for diaspora registration, but even diaspora voting as may be necessary, and that Liberians, regardless of where they live, as other nationals, should have the opportunity to support and vote in the elections without also having to incur the additional cost of tickets, travel, time from work, and all of those other considerations that have to be made if they must come twice to first register and then come back to vote. So we do support diaspora registration as it is, and we want to propose further that we consider diaspora voting as well. As to the 30% for any one gender, We do support the 30%. However, we want to propose the removal of the good cause clause, which requires that the political party shall provide a listing with not less than 30%, but can show good cause if they cannot reach the 30%. And that good cause is at the discretion of the National Elections Commission. We oppose that component of the law, and we ask that it is removed, propose that it is removed, and that the shall ensure 30% remains as is without the good clause or discretionary powers of the NEC. This actually is no different as it is from the endeavor to ensure. Because what you're basically saying is the parties should have 30%, but come and show good cause why you didn't meet the 30%, and we can decide whether it's good cause or not. We think if we want to be intentional about the 30%, then we must remain intentional about the 30% and not try to play games or create loopholes that political parties can pass through. We also want to raise the concern, the issue about secondment of secondary magistrates to hear election matters as hearing officers. We think it's additional burden on the judiciary, and moreover, these election issues also end up going back to the judiciary on appeal. So if we're requesting secondment of secondary magistrates, we're also taking magistrates out of the courts and cases that they have to handle for the people to hear election matters. We believe that that proposal does not support the effectiveness of the judiciary, nor does it support the separation of powers, as we do know that a few matters does go back to the judiciary. Yes, we do.
Everything you said?
Yes, we do. We should say we sent to you. Thank you. Number 8 on that, we want to also reference the provision which talks about serving complaints on all participants in an election to be part of the hearing of electoral complaints. We think that is muddying the water. If a complainant complains candidate B or candidate C, that candidate remains the defendant and should be served. If you have 25 persons contesting an election, you're saying that you're going to serve all 25 candidates even when they have no part to play. We also need to recognize that our law has what they call standing. And if these participants do not have standing, no matter what, are we serving them citations to be a part of hearing processes when it's just between two candidates. So we propose that that is removed from the law, and that service of complaints on the candidate being complained is served on that candidate, and that the hearing is held between the defendant and the complainant and not every participant in the election. We also want to reference the provision on the appeal process. We do recognize that the law provides that the evidentiary process will not follow the strict evidentiary rules as per the civil procedure law, which we don't have an issue with. However, the law also then provides that the appeal process is going to follow the strict appeal process rules. That means you have to announce an appeal in open hearing. You have to file your bill of exception in 24 hours. You have to file your appeal. We believe that the appeal process is very rigid and the time is very short to complete such process. And if we're going to have the process of the hearing process and evidentiary process not follow the strict civil procedure laws, then we have to look at how the appeal process cannot be as rigid, which tends to either prevent appeal, which is, as we know, a constitutional right, but also makes the process very difficult for it to get to the judiciary. The next on our observation is the increase in payment by 100%. This law requires that the payment for the precedence of registration of candidates goes from 2,005 to 5,000, 1,005 to 3,000, 750 to 1,005, 500 to 1,000. We reject that proposal. We believe it is expensive for candidates to be able to pay that amount. And what this is actually doing is keeping leadership away from the poor. There is no requirement, we believe, that should be as exorbitant or expensive to prevent citizens, ordinary citizens, from wishing to represent their people. And when we're charging 3,000, 5,000, 1,000, $700, $1,500, when our annual average salary is $350, we're definitely preventing a lot of common people from actually participating in elections just because they don't have money for registration. This is how we have people being godfathers, paying for people's registration, having holds over candidates, and determining what to do when they do actually get elected to represent the people. We think the amount should remain as is and to make it affordable for ordinary citizens to participate in our electoral process. Reduction in voting hours. I believe our colleagues in the opposition have raised that. We also object to the reduction in voting hours for reasons stated. And lastly, but not least, we want to reference the headquarters being in the immediate environs of Monrovia. We support that provision, but we however ask for specifications as to what the immediate environs of Monrovia is, that it is specifically defined or specified radius is stated so that we know what the immediate environs of Monrovia is. And we, however, would like to propose that the approval of the NEC for the headquarters to be in the immediate environs is removed from the law, so that it is, instead of approval, it is information that a party that cannot find land or rental space or lease space in Monrovia and wishes to use the immediate environs can inform the NEC that it made attempts to find headquarters within the city but cannot, and so they're finding it within the immediate environs, and that they cannot withhold approval. Hence, instead of approval, we're proposing that it's information to NEC, and that immediate environs is defined as for the specific radius. Thank you.
Thank you. So when should we expect you to be expect your submission? 24 hours. Union? We expect you to talk more, so you make all the noise.
Greetings to the chair and members of the Committee on Judiciary, Human Rights, Claims, and Petition of the Senate. It is a pleasure being here. As you say, like other speakers have mentioned, we did receive your communication very late, so we did take some very hard view to present some initial points. First, before proceeding with our perspectives, we would like to express our thanks and appreciation to the committee for inviting us. Second, our perspective is that the integrity, transparency, and credibility of any electoral process or framework depends on shared development and understanding of such a framework through collective action. We are pleased that you've invited diverse stakeholders to inform your decision-making in the context of lawmaking. Now to the bill. We note that the draft act has communicated first last page numbering, which present difficulties in terms of proper referencing by page rather than by section. We respectfully suggest that every page be numbered to ensure clarity, professionalism, usability, and accountability. Second, we should state that to the best of our knowledge, the elections law of Liberia since 1986 have been amended about 3 times, in 2003, 2004, and 2014. Having compared and contrasted the 3 relevant elections laws and other relevant documents, including the Constitution, we are pleased to note that under Chapter 1 of the current bill with respect to definition and general provisions, there are some problematic feelings. Section 1.2 on definition suggests amendments by deletions of subsection 1.2 C, M, N, P, U, and V of the new elections law of 1986. We wish to state that section 1.2 C of the bill on the definition of political parties is problematic in that it defines political parties as association of qualified voters. This should and must not be the case. We suggest that the original definition of political parties under Article 78 of the Constitution of Liberia of 1986 be maintained. A political party should and must not necessarily be association of qualified voters, but rather people with common purpose. Section 1.2 FL provides for the inclusion of a new term titled gender. This is a welcome development in the context of inclusionary politics. Section 1.2M on domicile. This definition is problematic because anyone can claim anywhere to be his or her domicile. It leaves the term domicile fluid and malleable. It can be claimed and abandoned at any time. Section 1.2P, we believe it is a necessary amendment by this particular suggestion. On the issue of the recruitment and appointment procedures of the Office of the National Elections Commission, by that I mean the 7 commissioners, we believe that the new suggestion for the constitution of an ad hoc committee of 13 persons is a welcome development. However, we believe that this is too large. 13 persons will recruit 7 persons. I mean, there are different institutions that are listed to form part of this ad hoc recruitment process, which will be subjected to nomination by the president and then confirmation by the Senate. For example, the Inter-Party Consultative Committee is requested to present 3 nominees on this ad hoc committee. Currently, we don't know the structure or configuration of the Inter-Party Consultative Committee. We hope that can be spelled out. In terms of that particular provision, there is also a sentence that one person who has an established enterprise in Liberia for now less than 5 years shall be nominated. That enterprise will have to be clearly defined as an enterprise, could be a business entity, and the Liberia Business Association has already been named under that process of recruiting the commission. That's the National Elections Commission. On section 2.2 of the bill, it seems to contradict section 2.1 in terms of the nomination of the commissioners. 7 commissioners shall be nominated for 7 years. It is stated in section 2.1, but then it goes down to say that 4 of the commissioners shall be appointed for 5 years. We believe that there will have to be clarity in that. There should be consistency. On the point of the removal of a commissioner, it is stated that this should be done in keeping with the rules of the House of Representatives and the Senate on impeachment of public officials. We hope those rules comply with the Constitution of the Republic, because there are some provisions of the rules of the House and the Senate that appear to squarely fit people who serve in both chambers. On the issue of the inclusion of diaspora citizens or residents who are Liberians or living in the diaspora, so to speak, under section 3.1 of this particular bill, we believe that the mechanisms of registration of diaspora citizens are not clearly articulated or specified. So we don't know whether they will come to Liberia or whether they will register at the respective embassies of our country as done in other countries. With respect to the registration of voters by valid Liberian passports or valid Liberian national identification card, we believe that this is a problematic provision because of access to the national ID. As we are aware, this process is currently on suspension and it has now resumed. So registration should not be tied to a national ID or the passport of Liberia. With respect to section 3.1a, which also talks about the issue of the voter roll. The voter roll has been a problematic situation in our country in terms of the publication. The time frame that is stated for the publication of the voter roll is too short. We believe this should be changed. With respect to fees that are specified in terms of the loss of a voter card, $5 or its equivalent in Liberian dollars, that seems too high for people who are in the rural areas of our country. It means that if you lose your voter card, you may not participate in elections on the basis of a fee of $5. Again, the publication of voter roll of 15 days, we believe that this is too short because there are contentions that can emerge as a result of the voter roll. The issue of gendering, like has been said by other political parties, this is a welcome development in the new bill in the context of 4.5 of the bill. However, the provision of good cause is fluid and can be abused by authorities. On the issue of the opening of the polls, section 4.8, we believe that the current system must or should be maintained instead of changing it to another level. The complaint process as stipulated in this bill is very short, 48 hours. That should be critically reviewed by this committee and considered. So far so good because of the timing of the presentation of your letter to the Presidium. We're able to review those points. So we hope to further present to you our written presentation within 48 hours. Thank you.
Okay. Dean?
So that doing your submission PUL, I heard that you made observations, but there were no recommendations. So you can think there. Okay, thank you.
All protocols observed. Honorable Senators, California. I submit these comments on the proposed amendments to the elections law, and my focus is straightforward. Any changes to these laws must be in the bounds of the 1986 Constitution, and they must be workable and implementable, given Liberia's current realities. We all want the best for Liberia. However, we need standards. It should be tied to specific grounds such as misconduct, also incapacity and death. What matters is that the standard does not become a political tool. We should guide against that. The bill should make clear that removal can only occur on narrow grounds listed in the statute itself. The issue of age being removed based upon the age. The age of 70, I feel is okay.
I concord with that. However, I suggest that to keep a commissioner on a 1-year renewable contract where institutional memory or specialized knowledge is essential. Meaning, if there is a commissioner who holds a volume of institutional memory and that commissioner tenure is over, I suggest that something be placed in the law to allow this person to have 1 year extra, so that during that period they can transfer some of those knowledge to another person, and not for that person to walk away with institutional memory and no good turnover. Next, section 2.9, powers and functions of the commission. The commission should be required to publish its own hiring, promotion, and termination guidelines. Submit an annual report, which should also include a number of staff, which is annual staff and assets assessment. By this time, I am in serious doubt whether anyone can account for the number of staff or the assets that the National Election Commission has at its disposal. I am encouraging that an annual report of this be done. Section 2.10C, assignment of commissioners to administrative areas. The current phrasing, to the extent practical and feasible, is too loose. It invites challenges and creates the appearance of favoritism. And it can also be used as a means to put hole into anything that is supposed to be regulated. I think there is a need for us to include a little bit of specificity. Also, a commissioner should not be assigned to an area that includes his or her county of origin. If I'm from Maryland County, I should not be assigned as an oversight to Maryland County. Maybe I should be sent to Bond County. Section 2.24, magistrates of elections. An open and transparent selection process sounds good on paper, but the bill needs to make concrete requirements. All vacancies should be advertised in at least 2 national newspapers and on the commission website. Applicants should hold at least a bachelor's degree and be subject to background checks and public vetting. So, magistrates should be thoroughly checked, their background before coming to that position, checked also, not to mention moral and ethical standard of those magistrates. The gender quota, I also support, not only because I'm a female, but because we want national inclusion. And for this reason, I encourage the gender quota to be upheld. Section 4.8 and 4.10, polling hours and polling places or access. Shortening the polling hours from 10 to 8 is risky
in a country where many voters travel long distances. The bill should add a simple safeguard. Any voter already in line must be allowed to cast a vote. And I also think that Liberia is still a fragile country, and I don't think it is right for us to bring the voting hours all the way down to 4 o'clock. Sometimes people wait until the sun goes down before they walk to the pool to vote. So I think these people should be allowed to vote also. Elect section 510, 512, and 513. Election complaints and basic due process, and should be clearly stated. Okay. Conclusion. Before I conclude, I also want to concur with the issue of the cooling time. As I said earlier, I recommend that this be revisited, the percentage for women be upheld, the rights of women and children in an electionary period should also be safeguarded. And then I'll finally conclude by saying the proposed amendment contains several useful improvements. At the same time, a few provisions risk creating new problems, either by imposing unrealistic burdens or by reaching beyond what the Constitution comfortably permits. The mandatory gender quota is what we look forward to. I thank you.
Thank you, Dave. Thank you. Yeah.
Huh?
Yeah. Yeah, go ahead.
Are
you speaking now or just a question?
No, just a concern for the record. I heard you saying I reject, I accept, I think this is good. Are you representing an institution?
Yes.
So were you speaking for the institution or yourself?
Well, my citation did not say specifically that you are going to be representing this institution, but because I'm the head of the institution and I answer for this document, since the document came in at a point, it came in on Thursday evening, and on Friday there were hardly sufficient professors on the campus. I cannot say we at this juncture when I am the sole author.
Okay. I just want to also be clear for the record, so we know. Okay.
You know that you work there. Okay, so we start from the back. Start from here.
Yeah. Thank you, Mr. Chair. Let me thank our colleagues from the political party for coming this rainy day to share their opinions on the election bill. So one of you mentioned something about the National Conference on Elections. Do you support that? And what will be discussed at that national conference?
Is that proposal from you?
One of them, yeah, somebody said that. Yeah. Because in follow up, because at the end of the day, we must take all your suggestions together in our own inputs. How do you suggest we come to a final version? That's the point. Yeah.
Yeah, Senator Chair, fellow senators, colleagues, we propose that as a means to get a consensus on the way forward, considering that some of the suggestions, some of the proposed amendments will require constitutional amendments. if possible, referendums. So we need to look at this. We have time. There's no need to rush into this. We have time. If we can call a national conference on elections reform and the way forward, I believe that coming out of that, we will all achieve our goals of moving forward. Thank you.
On the proposed 30% gender quota, if we pass that into law, how do we implement? How will it be implemented? In practice. Then we approach what the bill suggestion. How do we implement that 30%?
So the chair in 2005, and I think that's the most relevant information I can give. The electoral laws indicated that political parties shall ensure that their listing of candidates include a minimum of 30% of female candidates. The law also said if political parties did not meet that quota, their entire listing of candidates will be sent back. I'm a product of that legislation because the National Patriotic Party at the time submitted a name of 100%, a listing of 100% of male candidates. Once that listing was sent to the Election Commission, based on that law, the listing was sent back to the political party and they were asked to put a minimum of 30% women on the list. That's how I got on that list to become the senator that I became eventually. So that is the law that was in place in 2005. Somehow in 2011, it was removed. That's why we started having all of the confusion about endeavor to ensure or shall. I think the amendment is saying shall, political parties shall ensure that their listings have 30% minimum of women. And I think this is something simple that can be done. It's not a difficult process, but I think the law should go further to say if it is not done, then what happens? It can't just be left open. Do it or you don't feel like doing it or you have some excuse for doing it. I think we should put back what is said in the 2005 law. We should also give a penalty if you don't do it, your entire listing is sent back, so it's serious. So that's my initial point.
So if all the political parties saying they are nominated 30% women, female, is there a guarantee that at the end, the legislation will be 30% women?
Senator, the point is that even when they send men, there's no guarantee people will win. What we're asking for is to provide an opportunity that women have a chance to participate. Everybody goes into that process to participate, and some men lose too. Many men lose because the listings are long. You got 10, 20 people in each area. So it's to open a door for female participation. This is what this course is all about. Because without it, the doors to the political parties are actually closed.
So it's not necessarily that 30% of the legislation will be women. Because you would say a 30% and everything else will be 100% men.
Hello. Okay. May I comment from that standpoint?
The question is not no, I know that. Go ahead. Maybe one of them will answer that question.
Am I protected?
Yes, please.
Thank you. Senator, I want to go back from the last question you asked as to women representation in the legislature. The 30% is not a guarantee for women representation in the legislature. What will guarantee women representation in the legislature is what we also call affirmative actions. That is having seats specifically for women. So if you have a seat or seats specifically for women, and 10 women are contesting for those seats, you know that woman would eventually win that seat. So you have a confirmed and sure way of having women in the legislature. If your concern is about women being represented in the legislature, then the Senate or the House or both should be intentional about having affirmative action bills that provide specific seats for women to contest for.
So
On the issue,
who will they represent? Which constituency?
they represent the same constituents that men do.
Which county? Which
which district? How does it work?
So, Senator, I'm responding to your question based on the issue around women being in the legislature, right? So you can have youth representation because they're representing 50% of the population. So you have women representation. You could have youth. You have seats restricted for youth representation. You could have seats restricted for persons with disability representation. You could have seats restricted for women representation. And
Change the constitution.
I don't understand.
It's clear. You know what the Constitution says on representation.
The Constitution says equal representation. The population is equally male and female. So the constitutional restriction that you're referencing is actually applicable in this case because if you have an equal representation of male and female in your population, then you should have equal representation in the legislature. So we cannot use the Constitution as a basis of not supporting equal representation or affirmative action that supports women representation in the legislature. Because the very population we're referencing as to who they will represent says the population of women is almost 50%. Also, when it comes to youth representation, we have over 70% of our population below the age of 35. Where's the youth representation in the Senate? So if we want to talk about constitutional representation of the people, then we have to be intentional about whether we provide for representation for women, representation.
Councilor, hold on 1 minute.
Can we come in?
Yeah, can we follow right there?
Can we come in?
Yeah, can we follow right there? Please. Yeah, thank you. Councilor, ANC, I understand your position on equal representation. That same constitution says how people can get elected into the legislature. Can you tell us?
The same constitution also provides for amendments. And those amendments allow.
Councilor, you're not answering the question.
Senator.
Councilor? No, Chairman.
That's why you say it.
No, Chairman, the ANC landed lawyer was telling us constitutional equal representation. To cut in the legislature, you have processes laid down by the Constitution, including being elected. Correct?
So let me come in if I may.
It can be changed though. Constitutional review.
Yeah.
That is different, Councilor.
So
you give me equal representation as contained in the Constitution, then you leave me another serious portion out that says how you can be equally represented by election.
So Senator, may I respond? Thank you.
I think,
Senator Chia raised the issue. Thank you. So,
they will not come back to you.
Yeah, I think, for the purpose of this, since, a female, really strong on this and the ANC back this, I think she will be the proper messenger on this one. So I will just yield that.
thank you. So Senator Chia raised the issue of equal representation. And that's why my response to the equal representation.
30%.
Okay,
How do we implement it practically?
right.
That's the question.
So we'll come to the 30%. But Senator Dillon, to your question, the very Constitution is a living, breathing body. And the Constitution provides for amendments. And it provides for how it can be amended to suit the people that needs. It's for the people. Councilor,
Councilor, I know that.
are you, Senator?
Thank you. I know that. The question was, how do people enter the legislature? Because you were making emphasis on equal representation, winning more than 50%, you this percentage. The Constitution also recognizes and dictates how people enter the legislature. That was my question. I know that the Constitution is a living document that can be amended to provide for or accommodate these things as we see the need. But as we speak, how do you enter the legislature? Are all my questions.
So, Senator, I don't think how people enter the legislature was being debated. I get where you're coming from, and we all do know how people enter the legislature. What we're discussing is how can we have more people enter the legislature to reflect the equal representation that Senator Che talked about. But I want to come to the 30%. May I come to the 30%? So,
Mr. Chairman, Mr. Chairman,
On the same issue, on the 30%.
this is what one of the speakers on the.
Do you agree on the 30% issue?
yes, sir. So, on the issue of the 30%, I would like to say if you're talking about the representation from the party, political parties can develop an implementation plan